From production is surface वाले
नहीं,
item
वो
one.
कुछ मेंशन कर रहे हैं, कहाँ पे मेंशन कर रहे हैं? हाँ बताइए क्या मेंशन कर रहे
It's serial number the daily publish.
हैं? क्या करना है?
It will be taken. I have filed the IU petition for it. I am the respondent number 2 and 3. I am the purchaser of land for ensuring the appearance of respondent number 1. के लिए मैं IU 8 orders का first case. Before I number 2.
कौन है? Respondent number
2 and 3 है. I am
2
the
and 3.
yes.
बहस के लिए तैयार है? तो बस ठीक है ना, बहस के लिए तैयार है, फिर क्या सोचना है?
लेकिन रेस्पोंडेंट नंबर 1 का अपीयरेंस नहीं हुआ, 4-5 डेट से नहीं हुआ है। हम
कौन है respondent?
Plant is the state of Jharkhand. I am the respondent. I am the purchaser of the land. Land was
Respondent number 1 is Mrs. Dabur India Limited.
limited. Yes, but it's the Dabur India Limited has sort of taken a stand in trial court that one of the plaintiffs has sort of wrongly made him party because he has already sold the land to in favor of my respondent number 2 and 3.
We'll see that.
Notice was issued to 180, but it was filed and it was filed after due date. That because it is not sent, so permission is needed to send it again.
आप पर्सनल सर्विस जाके करके आइए। कहाँ है इनका ऑफिस? वहीं चले जाइए। पर्सनल सर्विस नोटिस नहीं सर्व करते हैं, टाइम से स्टेप्स नहीं लेते हैं। आई गिव यू 10 seconds, अभी रुक जाइए।
From production is item 1, DT.22.07 of 2026.
Matter relates to Jharkhand trained Madhyamik Acharya competitive combined competitive examination 2022.
The entire name of the exam from the writ petition.
Annexure 1
No, writ petition में वो हिंदी वाला मत दिखाइए।
writ petition में University I have written regarding the advertisement annexure 1 subparagraph
ठीक।
paragraph 5 University.
When was the examination held?
Examination held in January. Admit card is there that in annexure 3 University.
When was the examination?
January 2026, 15th January and 19th January. Four papers were there, Your Lordship. 4 examination was held, Your Lordship. First
15/1
qualifying exam.
भाई डेट बताइए मैडम, इतना आपको कहीं जाना है?
नहीं।
मुझे कहीं नहीं जाना, इसलिए आप आराम से डेट बताइए। 15/1 2026 and
on second exam was on 19 January 2026.
This is prelims.
First was of qualifying nature and others were related to the subjects of petition, Your Lordship.
Paper 1.
Paper.
She applied for 3 posts, Your Lordship. Madhyamik Acharya AI and coding, Madhyamik Acharya computer science, and Madhyamik Acharya cyber security and data science.
With the same examination, you can apply for 3.
Because eligibility criteria for all these 3 examinations were same.
So what happened?
Your Lordship, third and fourth exam, Your Lordship, on 21st January 2026. Thereafter, Your Lordship, a list of shortlisted candidates were published for document verification.
When?
On 10th of June 2026. Annexure 4. The roll number of petition was there, Your Lordship, against the subject, concerned subject, Your Lordship.
What is your roll number?
136621.
13662. You are general category or what category?
ST.
You submitted your all the documents?
Yes, all documents were submitted, Your Lordship.
Okay.
And Your Lordship, again on 18 June, I were personally invited by email for document verification. On 18 June 2026 itself, Your Lordship, at 12:29 p.m.
List was published on 10/6/26.
Yes, Lordship.
They are
Thereafter,
called for verification of documents on 18/6/26.
Yes, Lordship.
Okay.
Which was to be held on 18 June 2026 itself from 2:30 p.m. to 12:29. I received the mail at 12:29 p.m. I appeared, Your Lordship, within due time, Your Lordship. I submitted all my documents, Your Lordship. Thereafter, Your Lordship, an objection was raised regarding my PG certificate, Your Lordship, by Annexure 7. Annexure 7, page 59.
Yes.
अन्याय ने जो लास्ट में हैंड रिटन पीजी का विषय विज्ञापन की निहित शर्तों के अनुसार नहीं है और उस पर नीचे में है क्लॉज 2 भी देखा जाए उक्त अनुपलब्धता के आलोक में अपना पक्ष सहित सहायक प्रमाण पत्र अभिलेख दिनांक 25/6 जून 2026 को अपराह्न 5 बजे तक अधोस्ताक्षर के स्वयं उपलब्ध कराना सुनिश्चित करें। 25 जून तक हमको क्लैरिफिकेशन मांगा गया, ये सब्जेक्ट के रिगार्डिंग दिया गया। सब्जेक्ट यूनिवर्सिटी जस्ट एक पेज पहले देखा जाए मेरा जो सब्जेक्ट के रिगार्डिंग ऑब्जेक्शन किया गया एनेक्सर 6 एमटेक का सर्टिफिकेट यूनिवर्सिटी इसमें जो सब्जेक्ट हां सब्जेक्ट
उसको सबसे इंपॉर्टेंट यही डॉक्यूमेंट
हां सब्जेक्ट में यूनिवर्सिटी हमारा लिखा हुआ एमटेक डाटा साइंस
नहीं पढ़िए
हां पढ़ हां दिस इज टू सर्टिफाई दैट Miss Srinatha Tigga, bearing university registration number so and so, has successfully completed the prescribed 4th semester course at Jharkhand University of Technology, Nampur, Ranchi, and has passed the final MTech Data Science examination of the Jharkhand University.
झारखंड यूनिवर्सिटी ऑफ टेक्नोलॉजी भी है क्या?
हाँ, ये परफॉर्मेंस पॉइंट बनाए हैं हम।
ये तो पहली बार सुन रहे
है झारखंड
चलिए
ये but it is there. It is at Nampur. It was established in 2016.
पुराना नहीं है बहुत नया
नया
Now your lordship will kindly come to page number 29 where the advertisement prescribes the eligibility criteria. Page number 29 is regarding the subject for which petitioner.
29 yes
Last bottom में देखा जाए लॉर्डशिप माध्यमिक आचार आर्टिफिशियल इंटेलिजेंस एंड कोडिंग और अदर टू भी इसी में है लॉर्डशिप माध्यमिक आचार साइबर सिक्योरिटी एंड डेटा साइंस थर्ड है माध्यमिक आचार कंप्यूटर ये तीनों सब्जेक्ट का कंबाइंड कंबाइंड एजुकेशनल
अरे पढ़िए ना कहाँ पर है पेज 29 में अभी हम पहुंचे हैं
लास्ट बॉटम में
पढ़िए रीड इट प्लीज
बॉटम में देखा जाए पदना माध्यमिक आचार आर्टिफिशियल इंटेलिजेंस एवं कोडिंग
read the qualification carefully
हाँ,
yes
तीनों का कंबाइंड क्वालिफिकेशन है लॉर्डशिप इसमें देखा जाए और जो सेकंड
MSc कंप्यूटर साइंस
हाँ सेकंड वाला देखें ME और MTech कंप्यूटर साइंस IT from a recognized university institution with at least 50% marks हम ये इसी बेसिस पे भरे थे लॉर्डशिप और ये दो पोस्ट और नीचे में दिया हुआ है दोनों पोस्ट के लिए डिमांड
ME और MTech कंप्यूटर साइंस IT
from a और हमारे
तो आपका डेटा साइंस बोलने से कैसे होगा
वही ऑब्जेक्शन रेज किया गया
तो सही ना ऑब्जेक्शन है हम थोड़ी डिसाइड करेंगे यहाँ
उसका क्लैरिफिकेशन है लॉर्डशिप क्लैरिफिकेशन जो हमको 25 तक जमा करने के लिए किया गया था यूनिवर्सिटी को मैंने एप्लीकेशन दिया एप्लीकेशन एनेक्सर 8 पे है उसके बाद यूनिवर्सिटी ने मुझे एनेक्सर 9 इशू किया जिसको मैंने विद इन टाइम सबमिट कर दिया एनेक्सर 9 देखा जाए
ये क्लैरिफिकेशन कहाँ है आपको
at page 61 यूनिवर्सिटी
61
This is to certify that Miss Srinatha Tigga, bearing registration number so and so, was a bona fide full-time regular student of Master of Technology in Data Sciences in this university. Further, it is hereby certified that MTech in Data Science is a.
They will decide equivalence.
Yeah,
They will decide the equivalence.
University has provided the certificate.
No. Equivalence cannot be decided like this. आपको अपने ही पता है डेटा साइंस एंड कंप्यूटर्स आर टू डिफरेंट थिंग्स ऑलटुगेदर
Data science is I have annexed one more document, Lordship. It is a specialized course in computer science.
I'll give you an example. A person may be very meticulous in operating computers, but he will not become a computer scientist, or he will not get his mastery in computers does not mean that he will be treated as a data science, data analysis is completely different.
Your Lordship, one post, concerned post is data science also, Your Lordship.
You
Three
do not
posts. I
know.
applied for 3 posts, Your Lordship.
Maybe,
Your Lordship, and
but
one-
they have not asked for this. Is it your case? Is it your case that ME or MTech in computer science or IT, right? This is a separate course being provided by the universities. Yes or no?
Your Lordship.
And
वो
there is
separate course नहीं Your Lordship, इसी course में ही है जैसा यूनिवर्सिटी का annexure 9 से है इसी में यूनिवर्सिटी से मांग
we
लीजिए
are not here to decide the
and Your
equivalence.
Lordship second thing में kindly be seen on और एक point मैंने देखा जाए जो result है Your Lordship मेरा लंबित रखा गया जो result निकला है
लंबित रखा गया है तो
हाँ एक मिनट annexure 7 में देखा जाए annexure 7 का last पैरा देखा जाए sorry annexure 7 Your Lordship thereafter result has been published Your Lordship and result में kindly be seen मेरी क्लैरिफिकेशन देने के बाद रिजल्ट सबमिट रिजल्ट जो पब्लिश किए हैं ईमेल से भी 24 को दे दिया वेल विद इन टाइम एग्जामिनेशन रिजल्ट इज एट पेज 67 पेज 68 में काइंडली बी सीन सेकंड पैरा क्लॉज अनिवार्य प्रमाण पत्रों अभिलेखों की अनुपलब्धता अस्पष्टता के आलोक में कतिपय अभ्यर्थियों का परीक्षा फल लंबित रखा गया है मेरा पेंडिंग रखा गया है इसके बाद हमारा वेबसाइट पे एक मिनट सर हमारा वेबसाइट पे कोई इंफॉर्मेशन नहीं है सडनली न्यूज़पेपर में 16 जनवरी का न्यूज़पेपर जो हम लगाए हैं लॉर्डशिप पे annexure 13 आता है कि काउंसलिंग होने वाला है 20 से 22 को और अगले मंथ तक सबको अपॉइंटमेंट लेटर दिया जाएगा वेबसाइट पे जेएसएससी का मैंने सर्च किया कुछ भी नहीं मिला जब स्कूल एग्जामिनेशन
पे रिजेक्शन ऑर्डर दे दिया है ना
रिजेक्शन ऑर्डर
in the sense that they are asking you to produce a degree which you do not have. They were still waiting that you will produce a degree.
Your Lordship, I have produced any और हम दिखा देंगे
क्यों
Lordship
नहीं दे देते एक लेटर?
हाँ
दे दीजिए।
रिजेक्ट कर देते
ठीक है your result is awaited. They will communicate you the result.
वही
That's
बात है
it.
Lordship मेरे रिजल्ट पेंडिंग रखे हैं और यहाँ देखिए
नहीं रिजल्ट आपका पेंडिंग नहीं रहेगा
रिजल्ट पेंडिंग रख के तो कुछ भी नहीं
कम्युनिकेशन नहीं हुआ
आप कर दीजिए जो आपको करना आप कर दीजिए अगर ऐसा नहीं है कि हम लोग बोल रहे हैं इसलिए उसको रिजेक्ट कर दीजिए अगर आपके पैरामीटर्स में आता है तो
नहीं
उनको
आता
कर
नहीं
दीजिए
आता बिकॉज़
एक बार यूनिवर्सिटी से भी किसी ने तो पार्टी बनाई यूनिवर्सिटी में तो नहीं है कि ये क्वालिफिकेशन
कौन है यूनिवर्सिटी के एडवोकेट यहाँ पर
क्राइटेरिया है वो
आप डिसाइड करेंगे इक्विवेलेंस देखिए वो अपने से ढीला रहे उनको पता है इक्विवेलेंस नहीं डिसाइड कर सकते
say that this has been issued by Jharkhand University 9 has been issued by the university. I have checked out from the university. They have said that they have issued it. But whether it is right or wrong, whether we can do it, it is the honorable court to decide.
ऑनरेबल कोर्ट सब चीज आप लोग गलत करते हैं ये और यहाँ पे ऑनरेबल कोर्ट के माथा पे दे दीजिए ये कोई तरीका है आप लोग का
Position of law that the equivalence or not has to be decided.
कल को बोलिएगा कि इंजीनियरिंग इन एआई इज सेम एज इंजीनियरिंग इन कंप्यूटर्स इंजीनियरिंग इन डेटा साइंस इज सेम एज इंजीनियरिंग इन यू नो डेटा साइंस में ठीक है इकोनॉमिक्स स्टैटिस्टिक्स वाले लोग भी डेटा साइंस करते हैं ठीक है उसके लिए कंप्यूटर्स पे मास्टर होने की जरूरत नहीं होती और ना ही ज्यादा कंप्यूटर्स पे स्किलफुल होने की जरूरत है डेटा साइंस इज अ डिफरेंट साइंस ऑल टुगेदर
It is for the employer to see whether it
But
meets
that
the
is the judgment of
That is
the
what I-
society.
नहीं जजमेंट नहीं आप उसको लटका के मत रखिए आप इनको जो करना है आपको
एक चीज और दिखा
बस काफी है ना मैडम आई विल नॉट डिसाइड ऑन मेरिट्स योर केस विल बी डिसाइडेड आप कितना दिन में कर देंगे कब से एग्जाम
नहीं एग्जाम तो
मैं
हो चुका
आज
है
ले रहे हैं फाइनल मेरे सब्जेक्ट का काउंसलिंग आज ले रहे हैं ये लोग
तो हो ही गया काउंसलिंग अब क्या बचा है
काउंसलिंग है उसके बाद अपॉइंटमेंट लेटर देंगे ये लोग
मतलब फर्स्ट राउंड ऑफ द
16
counseling
तारीख
done
को तो
they were invited your lordship they failed to produce the relevant documents in terms of the
they were also
advertisement.
invited
Huh?
in the counseling
She was also invited in the counseling and a so-called notice was issued due to non-submission of the requisite educational qualification in terms of the advertisement. She has submitted she has submitted the reply and we found it not correct, it's not valid because your
लंबित ये लोग
कोई बात नहीं लंबित नहीं रहेगा मैडम
लंबित रख के आप कैसे कर
आप
सकते हैं
उसको
आगे
हम
आप उसको डिस्पोजल कर
डिस्पोजल कर
यूनिवर्सिटी तब तक ये लोग 16 ये देखा जाए लॉर्डशिप।
मैडम रिजेक्ट करने में 1 मिनट नहीं लगेगा क्योंकि आपका जो वो है ना क्वालिफिकेशन इन माय लिटिल नॉलेज ऑफ साइंस व्हिच आई हैव राइट इज नॉट द सेम।
चलो लॉर्डशिप एक चीज और दिखा देते हैं, जो तीन
She is
सब्जेक्ट है
claiming
लॉर्डशिप,
that
एक मिनट
that
सर,
is-
तीन
that is
सब्जेक्ट है लॉर्डशिप,
incorrect.
क्या क्या है वो देख लिया जाए।
आई एम नॉट हियर टू
अब
डिसाइड
तीनों
ऑन
सब्जेक्ट के लिए कॉमन क्वालिफिकेशन है लॉर्डशिप, हम इसे दिखा रहे हैं। दूसरा पोस्ट ये लॉर्डशिप, एक बार दूसरा पोस्ट का मेरा नाम देख लिया जाए, माध्यमिक आचार्य साइबर सिक्योरिटी एवं डेटा साइंस। डेटा साइंस के पोस्ट के लिए भी हम अप्लाई किए हुए हैं,
ठीक
और दोनों के लिए कॉमन है, वो जो एलिजिबिलिटी क्राइटेरिया कॉमन है।
ठीक
तो एमटेक कंप्यूटर साइंस, तो कंप्यूटर साइंस में डेटा साइंस साइबर सिक्योरिटी सब आता है, वही हम एक्सप्लेन करना चाह रहे हैं कि ये जो साइबर सिक्योरिटी डेटा साइंस हुआ, एक पोस्ट है। एक बार पेज 29 30 फिर से एक बार देखा जाना है। तीन पोस्ट जो हम एग्जाम की दिए हैं, आप फिर से देखा जाएगा। तीनों के लिए जब कॉमन क्वालिफिकेशन है तो इक्विवेलेंट कैसे नहीं हो सकता है लॉर्डशिप, यही हम लोग कहना चाह रहे हैं। देखा जाए पहला पोस्ट का नाम माध्यमिक आचार्य, बॉटम में लॉर्डशिप पेज 29, माध्यमिक आचार्य आर्टिफिशियल इंटेलिजेंस एवं कोडिंग, एआई एंड कोडिंग। दूसरा पोस्ट है माध्यमिक आचार्य साइबर सिक्योरिटी एंड डेटा साइंस, और तीसरा पोस्ट है माध्यमिक आचार्य कंप्यूटर साइंस। तीनों के लिए देखा जाए लॉर्डशिप कॉमन क्राइटेरिया है, एलिजिबिलिटी क्राइटेरिया। तब तो ये साइबर सिक्योरिटी एक स्पेशलाइज्ड सब्जेक्ट होता है कंप्यूटर साइंस में, ये डेटा साइंस भी एक स्पेशलाइज्ड सब्जेक्ट होता है कंप्यूटर साइंस में, और ये जो एआई होता है कोडिंग होता है ये भी एक स्पेशलाइज्ड सब्जेक्ट होता है कंप्यूटर साइंस में लॉर्डशिप। इसीलिए ये कॉमन क्राइटेरिया है लॉर्डशिप, तो कॉमन क्राइटेरिया है तो उस हिसाब से तो ये लॉर्डशिप
these are I understand these are absolutely specialized specialized
सब्जेक्ट है कंप्यूटर साइंस,
but we are not experts.
Leadership, who will clarify this university to
As of now there is no improved order. As of now there is no improved order. Unless there is an improved order, unless they give a reason, what should I examine? इतना सा तो बात है।
हाँ, एक तरफ लंबित रख के दूसरी तरफ ये प्रोसेस कैसे कंप्लीट कर सकते हैं लॉर्डशिप, प्रोसेस कंप्लीट करने वाले हैं।
मैडम आप एकदम चुप हो जाइए। WPS number 2207 of 2026. Heard the learned counsels appearing on behalf of the parties. This petition has been filed for the following reason. The learned counsel for the petitioner submits that the petitioner participated in selection process
Advertisement number 2 of 2025
pursuant to advertisement number 2 of
2025
2025 dated 10/6/2025 and was called for counseling. However, an objection was raised by the respondent.
Jesus.
Respondent number
Respondent number is also. Your also 4 and 5. 5 examination complete.
respondent number
5.
5. Respondent number 5. On 18th of June 2026, that the petitioner does not have the required qualification as per the advertisement.
In terms of the
In terms of that, the learned counsel has referred to the provisional degree certificate and has submitted that the petitioner is holder of MTech in data sciences from the Jharkhand University of Technology, Ranchi, held in the month of October 2024. She submits that the university has also issued a clarification that MTech in data science is a relevant / equivalent discipline to MTech in computer science and engineering within brackets CS. The learned counsel submits that the required qualification was ME or MTech within bracket computer science slash IT bracket close from a recognized university slash institution with at least 50% marks. The learning councils
Public ME or MTech computer science.
public
नीचे page number 29 में बोला public or ME or MTech computer science.
यही लिखा है सर,
वो इसमें
यही लिखा है एग्जैक्टली ये पेज 29 में है bottom में.
जी sorry.
The learning council submits that three different posts had the same required qualification, and the qualification of MTech in data sciences is equivalent to ME or MTech within bracket computer science slash IT bracket. She submits that by virtue of election 7 dated 18/6/2026, the petitioner was asked to give a clarification, to which the petitioner duly responded. But as per election 12, the result of the petitioner has been kept in abeyance. And a newspaper report has been published that the appointment letter is going to be issued shortly. The learned council submits that it is unfair on the part of the respondent 5 and 6 to keep the result in abeyance with respect to some of the candidates and publish the result, and thereby frustrate the entire case of the petitioner. The learned council for the JSSC has submitted that the Master of Technology in Computer Science slash IT is not equivalent to Master of Technology in Data Sciences. He has further submitted that the university has no locus to decide the equivalence, and further the university has not stated that it is equivalent. Rather, the university has stated that it is relevant slash equivalent. He submits that, of course, no formal order with regard to the final outcome of the participation of the petitioner has been communicated so far. The reason for however, the objection has been communicated after hearing the learned counsel for the parties and considering the fact that the result of the petitioner has been kept in abeyance. Kept in abeyance here, na?
Kept pending.
Has been kept pending.
Pending consideration.
Has been kept pending consideration. And it appears that final selection list is likely to be published shortly. This court is of the considered view that the JSSC cannot act in such a manner, and the petitioner has a right to know the ultimate outcome of their candidature. Single petitioner
Single.
of a male and female. Male and female of a candidate. Who belongs to scheduled tribe category. Who belongs to scheduled tribe category, as stated by the learned counsel for the petitioner. In such circumstances, this court directs the respondent number 5 to immediately communicate the final outcome of the participation of the petitioner in the selection process. आपका मेल आईडी है? दीजिए। आपका नहीं है, आपके लिटिगेंट का।
लिटिगेंट्स का है लॉर्डशिप, मेल पे जो भेजे हैं वो उसी वही मेल आईडी है।
आप लिख के दीजिए।
अनेक्सर 11
लिख के दीजिए मैम, लिख के दीजिए। At the mail ID which is already available with the petition, with the respondent, a hard copy of the same we also communicated to the petitioner through speed post. दिक्कत है ना, आप लोग सारा मेल से ही कम्युनिकेट करते हैं, खाली मेल से, मेल आईडी से ही कम्युनिकेट करते हैं।
लॉर्डशिप देखा जाए कि पोस्ट भी सारा भरा नहीं है,
ठीक है,
पोस्ट भी कम ही पोस्ट का ये लोग निकाले हैं, मतलब जितना ऑब्जेक्शन हुआ किसी को कंसीडर ही नहीं किए। सारा पोस्ट के लिए रिजल्ट नहीं निकला है, जितना पोस्ट लोग एडवर्टाइज किए थे।
इन सब बातों का क्या रेलेवेंस है? नहीं रेलेवेंस है ना। You want your reasons, you will get your reasons. Right? चलिए आप communicate कर दीजिए। The deed will be done within 1 week.
One week
One
can
week
be indicated.
अब आपके कौन रिटायर होने वाले हैं, कौन छुट्टी पे जाने वाले हैं, सब कहानी
नहीं हम करवा देंगे। There in the advertisement there is no mentioning that the covalent degree will be also considered because you are not speaking.
वो आप जानिए आपको क्या लिखना है, तो ठीक लिखना है। Sorry,
Now it is post
डेट दे दिया 1 week। 1 week काफी है, इससे ज्यादा तेजी से हम लोग अभी जुडिशियली नहीं सोच रहे, इससे ज्यादा स्पीड नहीं हम लोग को सोचना है।
मेरा यही था लॉर्डशिप, मैटर तो पेंडिंग रहता जाता है लॉर्डशिप।
नहीं, मैटर नहीं पेंडिंग रह सकता।
From supplementary list powder beauty fat item 1.
ये चीज एक दिखा दिया जाता है लॉर्डशिप के बिफोर
First of all, filing number 4691 of 2025.
कम्युनिकेट कर दिया जाए।
मैडम इतना चीज नहीं हो सकता।
Item 1.
4 weeks to do remove the defects. Defect of the degree has been found.
FA number 4691 of 25. Time to 14th August is granted to the petitioner to remove the surviving defects from it. If the defects are removed within time, both is submitted.
Item 2. First appeal filing number 7235 of 2025.
Say now.
Item 3. First appeal filing number 10407 of 2025.
Say now. Continue.
From daily list powder beauty fat item 5. First appeal filing number 3671 of 2025.
Say now.
Item 6.
Say now.
Item 7.
Yes.
The limitation of it is
बाकी सब डिफेक्ट रिमूव हो गए हैं। सेम ऑर्डर पे सब डिफेक्ट रिमूव कर दिए।
defect has been displayed.
एक बार जरा दिखाइए, उन्हीं को दिखाइए। एक बार चेक कर लीजिए ठीक से.
For financial disposal, item 3, second appeal 423 of 2003. Item 3.
Who is for the applicant?
Item 3.
Mr. Sasan Singh.
ये हो गया, देख लिया सारा डिफेक्ट रिमूव हो गया आपका. तो फिर बिना देखे जो है ना यहाँ पे सबमिशन मत किया करिए. कॉस्ट हम लगाने लग जाएंगे अगली बार से बिना फाइल देखे. यहाँ पे हम आपके मुंशी हैं.
सबसे इम्पोर्टेंट डिफेक्ट तो
कुछ भी बोलते हैं.
बिना देखे नहीं बोला.
मतलब whatever you want to say, you will say all the defects have been removed. अगली बार I will remember. अगर एक बार भी आपका ये गलती हुआ ना, कॉस्ट लगा देंगे आपको. कितना साल हो गया आपको? 10-15 साल तो हो गया. नहीं हुआ? कितने साल हो गए? चलिए 10 से कम है तो आज माफ. ऐसा नहीं करिए ना. आप ही के सबमिशन पे लिखा देंगे तो आप गड़बड़ हो जाएगा ऑर्डर. कैसे बोल दिए सारा डिफेक्ट रिमूव? तो हमको लगा हमने कुछ गलती कर दी. ये इंप्रेशन कहाँ से गैदर करते हैं? बिना रिकॉर्ड देखे हाउ डू यू गैदर दिस इंफॉर्मेशन? आपका क्लर्क आके बताता है. जब फाइलिंग नंबर से आता है ना तो लिमिटेशन, तो नोटिस लिमिटेशन तो आगे पे ऑर्डर्स पे आएगा विद केस नंबर. इतना मायूस होने की जरूरत नहीं है. आगे से ध्यान रखिए भाई. इससे हम लोग के लिए यही सब चक्कर में हम बीमार पड़ गए कि आपसे ज्यादा फाइल हमको देखना पड़ता है.
पिछले समय लोग में होती रही मुंशी लोग अब कोठी नहीं जमा किया. हो सकता है जो दिया कि नहीं लिया हमने स्टेट का फाइल.
आई टेल यू वन.
हो सकता है.
लेट मी शेयर वन थिंग. हम लोग भी प्रैक्टिस किए हैं. जस्ट अ मोमेंट. जब तक मुंशी हमको डिफेक्ट फ्री नंबर नहीं लाके दे दे उसको पेमेंट नहीं करते. समझ गए ना? उनके बाद से चलिएगा पूरा ऑफिस बिक जाएगा. वो तो बोल देंगे हो गया डिफेक्ट फ्री हो गया. डिफेक्ट फ्री नंबर लेके आइए, अपना पेमेंट लेके जाइए.
ठीक है. इसको
इस प्रिंसिपल को आप अपने ऑफिस में लगा दीजिए. देखिए आपका एक भी डिफेक्ट नहीं है. इस अपील में आपको दे देंगे ना. हम आपको सेम ऑर्डर कर दीजिए. 14 अगस्त तक वो लिए हैं. विनीत जी बहुत सारे ऑर्डर्स. विनीत जी वो सेम ऑर्डर ट्रेन फ्री है, ध्यान रखिए.
Item 3.
एडिशनल एविडेंस का कहानी खत्म हो गया. चल गया.
Additional evidence collection is passed on March only and passed an order will to be considered at the time of judgment. Which I find an application for training of additional substantial question of
सब्सटेंशियल क्वेश्चन ऑफ लॉ कब बना था?
but that is your 19/7/2006 order number 4.
तो अभी आपका केस करने का मूड नहीं है.
Starting if you are so please then you are
सी 2003 का केस. आपने एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ को कब अप्लाई किया? 2026 में. कितना साल बाद? हाउ मेनी इयर्स? टेल मी हाउ मेनी इयर्स यू हैव टेकन. और सूट 99 का.
specific
तो
performance
इसका वो स्पेसिफिक परफॉर्मेंस का है। और एक दो जनरेशन बीत जाएगा, केस इंफ्रैक्शन हो जाएगा, ज्यादा अच्छा। बताइए, इज इट फेयर? ऐसे तो नहीं होता है, कोर्ट प्रोसीडिंग्स इस तरह से नहीं चल सकती। वी आर नॉट रिस्पॉन्सिबल फॉर पेंडेंसी इन द हाई कोर्ट, यू पीपल आर रिस्पॉन्सिबल। तो वैसा कुछ नहीं हो सकता। I do not know. I just do not know. देखिए इतना 99 का रिकॉर्ड हम खोल के नहीं पढ़े, बता दिया। आप लोग कन्वीनियंस कंपाइलेशन फाइल किए तब फाइल करिए तब। नहीं क्यों हमको सुनना है? आप कन्वीनियंस कंपाइलेशन फाइल करिए। I will not touch them because I have suffered because of this bacteria into that file. Okay? You file your convenience compilation. I will बस plain written statement आपको जो फाइल करना है करिए। आप अपना करते रहिए। We are not going to, this is too much for a court to bear. और आपने रिप्लाई फाइल कर दिया एडिशन से?
Yes, we have filed.
Your petition is a detailed petition?
Yes, it's a detailed.
Your reply is also detailed?
Yes. Reply is detailed and we have given a short synopsis with list of dates. Yesterday. Earlier we have given, then we have given again a revised with some details.
क्या supplementary affidavit? What is the supplementary affidavit? तो कुछ भी फाइल करते हैं सेकंड अपील में? अरे हम तो कॉलेज में भेज देंगे आप लोग सबको।
एडिशनल एविडेंस के लिए ऐसे दिए, पहले तो एडिशनल एविडेंस दिए फिर उसके ऐसे दिए, वो सही है।
पर उसको भी रख दिया जाए, उसका हम आर्गुमेंट नहीं करेंगे, लास्ट में नहीं करेंगे।
फेज वाइज आना, पार्ट बाय पार्ट।
So आइए को डिस्कस इज नॉट रेस्ट करते।
आज इसको करेंगे।
क्यों नहीं आज ही करते हैं, आज
इसमें सबसे क्वेश्चन ऑफ लॉ है वो।
नहीं ये तो आइए जो आप फाइल किए, ये जो सप्लीमेंट्री जो फाइल,
मैंने उसको लास्ट में किया
नहीं सप्लीमेंट्री
लास्ट में ऑर्डर लिखाया है कि टू बी कंसीडर्ड टाइम ऑफ मिलॉट की।
आई विल नॉट टेक दैट रिस्क।
ऐसा कुछ भी नहीं है जो कि हमको आर्गुमेंट करना चाहिए, जस्ट उसको लास्ट में किया है।
देखिए ऐसा है, आप एक चीज समझिए प्रॉब्लम क्या है। 99 का सूट 2026 में पहुंच गया, 2027 में भी डिसाइड होगा नहीं पता, मेरे लाइफ टाइम में डिसाइड होगा हम नहीं जानते, राइट? क्योंकि अभी एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ। दूसरा चीज क्या है, अगर इसमें कोई भी चीज फाइनल जजमेंट में छूट, अगर कोई सब्स्टिट्यूशन छूट गया तो कोई भी छोटा चीज छूट गया, केस रिमांड होकर सीधे सुप्रीम कोर्ट से हम लोग के पास वापस आ जाए। मेरा जजमेंट सही हो गलत हो सेटिसाइड हो जाए, उनको कोई तकलीफ नहीं, लेकिन रिमांड होना समथिंग व्हिच इज वेरी वेरी सीरियस इन अ केस व्हिच इज अराइजिंग in the year 1980, that too a suit for specific performance. इसीलिए जो चीज आपको नहीं प्रेस करना है अभी से लिखिए नॉट प्रेस, नहीं उसको हम रिकॉर्ड से ही हटा देंगे।
छोटा सा खाली फैक्ट
नहीं कुछ हमको कुछ फैक्ट देखना नहीं है, आप सप्लीमेंट्री एफिडेविट को प्रेस कर बताइए। देखिए आप यू जस्ट अंडरस्टैंड, अगर ऐसा हो रहा है ना, ऐसा हो रहा है, एक आईए पेंडिंग रह गया किसी का, एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ का, केस डिसाइड हो गया, वापस आ गया केस। आईए फॉर एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ वाज पेंडिंग, नो ऑर्डर वाज पास्ड।
हम पॉइंट आउट कर देंगे, जैसे आर्गुमेंट कंप्लीट हम पॉइंट आउट कर देंगे।
आप ही बताइए आपको इस डॉक्यूमेंट को प्लेस करना है।
मिलॉर्ड ये जुडिशियल जजमेंट से मिलॉर्ड वो खाली जाने से प्रीएम्पशन अराइज करता हुआ है, मेरा एडजेसेंट मेरा एक और प्रॉपर्टी उसके रिगार्डिंग।
So you want to press it? हम आपको कहाँ मना कर रहे हैं कि आप मत प्रेस। I'm not putting any pressure on you, but I just want to know whether you want to press it or you don't want to press it. If you do not want to press it, then I will record that you are not pressing.
Basically, I have not gone through that idea because the last occasion, Lordship has directed to be considered time of hearing. Paper on the merits were not under the question that would be considered later period.
Yeah, क्या है इनका एडिशनल सब्सटेंशियल क्वेश्चन?
एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ जो भी बोल रहे हैं, ये चार प्रपोज किए हैं।
क्या है बताइए?
ये आइए जो इनका है, इसका
डबल सेवन
डबल फाइव डबल
डबल सेवन
क्या है?
पेज 4 में फर्स्ट जो बोल रहे हैं, बोनाफाइड परचेजर by shifting the burden of proof upon the plaintiff without defendant first discharging their initial burden of proving that they were transferees for the value in good faith and without notice. On this, we have pointed that there is a specific finding of fact about discharge of the burden of proof by the defendants, and there is a discussion based on facts. So it cannot be a question of.
So
And
it is already decided
It
and
is already
taken
decided.
care of.
Yes, and there is no perversity.
Okay, let us see each one of them. One का आपका reply देखते हैं.
Yes. Paragraph 8, page 2, paragraph 8 of our reply. Page 2, para 8, last but 3 lines. That
Yes.
regarding the proposed additional substantial question of law number 1, there is proper legal findings supported by cogent reasoning which are based on evidence of record. While deciding the issue of bona fide purchaser under section 19B of the Specific Belief Act 1963, the learned first appellate court has duly noted and taken into consideration the fact that the initial burden to show that subsequent vendee had no knowledge of earlier agreement is always on the vendee, and that burden has been discharged by leaving negative evidence, which consists of its statement denying the knowledge of the notice. Thus, it is not correct to say that the burden of proof has been shifted upon the plaintiff without the defendants first discharging their initial burden of proof.
Where are those findings?
Yes.
Paragraph.
Page 11 of the learned appellate court's judgment. Page 11. Page 11, the last paragraph.
Page 11.
Page 11, this last paragraph. Internal page 11.
Yes.
It starts with the line. It is a settled principle of law. What is a settled principle?
Yes.
It is a settled principle of law. Durga Prasad and another person, Srimati Leelavati and another, in 1972 Allahabad case mentions that the initial burden to show that the subsequent vendee had knowledge of the earlier agreement is always on the vendee. That burden is discharged by leaving negative evidence which consists of his abatement.
His statement.
Consists of his statement denying the knowledge of the notice. After this is done, burden shifts to the other party to show that the vendee had knowledge of the earlier agreement. Now, the perusal of the evidence, as already mentioned above, none of the witnesses examined by the plaintiff has uttered anything to suggest that the defendant number 2 or 3 had ever any knowledge about the said agreement for sale between defendant number 1 and plaintiff. The only argument advanced by the learned counsel of the appellant raised in this respect is that, as the defense have denied the possession of the plaintiff, but the
You
matter
have left one line. The only argument advanced by
the only argument advanced by the learned counsel of the appellant raised in this respect is that as the defense have denied the possession of the plaintiff, but the materials and evidences in the record shows that the plaintiff is in possession of the suit land. Hence, it be construed that the defendant number 2 and 3 had a constructive notice of the same agreement. He, in support of his contention, relied upon the decision of the apex court reported in AR 1967 Supreme Court, 1094 Ramvila Soja and others.
Yes, what do you have to say?
Yes, Reliance Soja, it is
नहीं,
quite.
एक करके. Yes, what do you have to say?
This particular matter, before I start, I'm just giving a brief nutshell of the facts.
No. You have proposed additional
Yes,
substantial.
just to give a brief fact, and then short, very short minute, just very short minute, and then I will come to substantial question of plaintiff's case is that the agreement was executed in the 1997 for a sum of rupees 27,500. On the date of agreement, I paid 22,000 as an advance, followed with delivery of possession. Thereafter, in the agreement, there was stipulation that remaining amount of 5,500 is supposed to be paid within a 3 months. The date end-to-end date is well mentioned in the agreement. I paid within a fraction, within 10 days, I made remaining amount of 5,500. And thereafter, I pursued the defendant's defendant number 1 to execute settlement in my favor. He denied and thereafter I came to know that defendant number 1 is entering into negotiation with defendant number 2 and 3, who are the husband and wife. And the purchase thereafter I gave a notice to defendant number 1 to execute settlement. They denied and thereafter they executed settlement after 2 days of my issuance of notice. Thereafter I filed a suit for specific performance. Now,
what was the time period?
The time period was
and when
3 months.
3 months.
3 months. When did you meet them?
I paid on 27/4/1997 agreement 22,000 was paid out of 27,000.
No, I want date of agreement.
Date of agreement 27/4/1997 is the date of agreement. Total amount is 27,500. Within 3 months, I have to make payment. But end-to-end date is not mentioned in the agreement. Within which I have to make payment. But I paid within on 27/7/1997. 27/7/1997, I paid 5,500. And thereafter I pursued for execution of deed. This remaining is
you paid the entire consideration.
Yes. Now, thereafter I pursued
entire consideration within time.
Yes. This is my only case. Thereafter, defendant number 1 who was
and you were in possession.
I am in possession, which is the finding on the record also, which is in my favor. Thereafter, defendant number 1 who was the original owner of the property, he did not put his appearance in the trial court. I just in the notices were issued to the parties, defendant number 1, 2 and 3, including the owner and the purchasers, all filed joint written statement. They denied such agreement to sell. And they claimed defendant number 2 and 3 claimed bona fide purchaser without notice and without knowledge of the agreement. Defendant number 1 did not appear in by cross-examination. Defendant number 2 and 3 appeared. The trial court formulated issues.
You want to argue then?
No, I'm just giving why I am arguing section 19. I am coming to the point section 19. During the course of trial, leader commissioner was appointed. Leader commissioner gave a report, specific report, the exhibit 6 perhaps, which gave finding that I am in possession of the property. In their date of purchase, date of entry into agreement, I was in possession of the property, and they were having the knowledge. They have entered into agreement in the deed in 1999. They have not taken abundant precaution while purchasing the property. They have not entered into. They have not took the notice of the purchase of the property before purchase of the property. Therefore, I am arguing and the trial court did not formulate.
What is the finding of the learned courts?
Yes.
Who was in possession?
With respect to this, there is finding in my favor that there was possession. I was in possession. Trial court gave a specific finding that when the lock and key was asked for, the plaintiff gave lock and key and the parties entered along with the leader commission.
That is a separate.
So
that does not mean that you were.
I have a lock and key of the premises, and they were also asked to open the lock pillar. I opened the door. That is coming the evidence. Therefore, I was in possession of the property on the basis of the agreement to sell.
Why all this is mentioned?
Yes, sir. I'm coming. Now, with respect to section 19B, the trial court did not formulate any issue, and with respect to possession also. Now, for the first time, the appellate court gave a specific finding, formulated an issue during the course of appeal by determination of point of determination, and formulated this particular issue. I will just, if you lordship permit, I will read paragraph number 11 again. Page number 11, sorry, page number 11. When the senior has read the finding portion, I am reading what contrast this finding has been given. Page number 11 again, my lord. May I please? Yes, my lord. There is the only, my lord. So first time this issue was there. Now, my lord, court says, my lord, it was their case to plead, my lord, that I was in possession, I was without knowledge, my lord. So now, how can I prove, my lord? They have to plead. They have a specific case. I was a purchaser without notice and knowledge, my lord. How can I discharge, my lord, that burden? And this burden has been casted upon the plaintiff to prove. Lord, it was their plea. The burden was upon them to discharge their burden first, then it can fall upon us. Because the burden of proof keeps on shifting from one person to another and time to time. Lord, it was the specific case that I was in bona fide purchaser without knowledge and without notice. Lord, they have to discharge the initial burden first, and then only I can discharge, Lord, I was in possession. And moreover, Lord, there was specific finding by the Federal Commissioner that I was in possession of the property, which has been considered by the trial court also.
There are two agreements.
No, only.
So your agreement is 1997, and you also entered into some agreement.
No, that's the
Same.
That is, you're saying is 1998.
19.
So you are in possession.
Yes,
You
yes,
were throughout in possession.
yes, yes.
When
That is-
were you given possession?
we have by the 99 century we have transferred the position, and that is our categorical case before the original court and the appellate court as pleaded and also evidence given.
The agreement was admitted not.
Agreement was disputed by us in the written statement.
The findings are.
Findings on the validity of agreement, there is a finding.
There is
That-
there is a finding that the entire payment was also made.
No, that there is a finding that the balance consideration amount has not been paid by them. There is a specific finding of that.
Does the agreement say that by virtue of this part payment or whatever, we are putting them in possession?
No, agreement doesn't say. Agreement doesn't refer to that. 2 pages agreement.
It is just an agreement of.
Yes, sir.
The property was mutated in your name,
Property not mutated in their name.
in your,
Our name, it is not.
when was the mutation done?
Nothing is there on the bottom.
Mutation, on mutation there is no pleading.
Okay, there is no material as.
नहीं
You see, they are the subsequent ventees. They said that they had no knowledge.
sorry
They said that they had no knowledge.
sorry I could not hear you.
They said that they had no knowledge. That is enough.
No.
Now you have to show.
Yes,
Now you have to show that they had knowledge.
Lord, they
What
have-
is the evidence that they had knowledge?
Yes, Lord, they say if they say, Lord, they have no knowledge, Lord, they have to plead and prove that they have on the site, they visited the site and they found that no one is possession, Lord. Lord, I will
Not
come.
necessarily.
I was expecting this. Lord, kindly takes transfer of property.
You see, we are not here to be
Lord,
the
No, I am suggesting, Lord. What is, Lord, section 3 of the Transfer Property Act says? Kindly have.
No, this substantial question of law now.
Lord, this is the main
Come to the
substantial
next.
question of law.
I'm not satisfied with this.
Lord, section 19, Lord.
I'm not satisfied with the substantial question of law. I'm not going to open a Pandora box over here.
Lord, kindly have, Lord, section 3
It
for
is
a
not
moment.
even a question of law in this case.
Just kindly have, Lord, section 3, Lord, for a moment and thereafter worship will dismiss.
Right.
section 3 my lord, kindly take specific relief at section 16 my lord, 16C.
Yes.
Your section 16B my lord.
Yes.
Who has become incapable. I'm sorry. Specific performance of contract cannot be imposed in favor of a person who has become incapable of performing or violates the essential terms of the contract on the part of remains to be performed or acts in fraud of the contract or willfully acts in variance with or subversion of in relation intended to establish by the contract. Number, kindly take point number 19 here, section 19 also.
So why do you want to
Sorry,
raise
I
this?
cited wrong. Section 19B. B. Any other person claiming under him by title arising subsequent to the contract, except a transferee for a value who has paid his money in good faith and without notice of the original contract. Now, we will kindly take transfer property. We are reading section 3. Reading a person is said to have notice as of a fact when he actually knows the fact, or when but for willful abstention from an inquiry or search which he ought to have made, or gross negligence, he would have known it. Your explanation 2. Any person acquiring an immovable property or any share or interest in any such property shall be deemed to have notice of title or any others, if any, of any person who is for the time being in full actual possession thereof. Today, if he says, my lord, that I am in possession of the property, when I claim, my lord, I am in possession of the property, and they say that I am a bona fide purchaser without notice, then, my lord, their actual possession they have to verify by them. My lord, before this has to be proved by them. Now, my lord, this regard, my lord, kindly take, my lord, this is in the same principle. So, I have given the judgment also to the lordship, my lord, AIR 2000 Supreme Court 2921. AIR 2000 Supreme Court 292. 2000.
कहाँ से ये सब प्रिंट निकालते हैं?
Sorry,
कहाँ से प्रिंट निकालते हैं? तो पढ़ा ही नहीं जाता है।
मिलॉर्ड पुराना जजमेंट है, मैं इसलिए उसको ही सेट करा, मतलब इधर 2000 वाला सेट कर रहा हूँ। प्रीवी काउंसिल का मिलॉर्ड इसी लो वैसा है।
इसमें पेज नंबर ही नहीं बताइए, किसमें है पेज नंबर, किसमें रनिंग पेज?
मिलॉर्ड ये वाला ले लीजिए।
आज हम सुनेंगे फाइनली।
हाँ,
बस हो गया, हम सुनेंगे कितना सुनना।
मिलॉर्ड the last time मिलॉर्ड I put a mark box मिलॉर्ड।
इसमें तो इस पंच में तो नहीं है।
With the along with the written notes I have given you. Back side मिलॉर्ड I have marked मिलॉर्ड।
A deemed notice. A person in possession is a deemed notice to the public at large.
Yes.
यही बोलना चाहता
हाँ। I am in possession of this property, milord, and when they say, milord, that they claim that they are a bona fide purchaser, then milord, they have to discharge the burden first, milord, that I am in possession of the property. I was not in possession when they purchased the property. The court has wrongly, milord, turned the burden upon me that merely by saying the averment that I am in bona fide purchaser, I am in possession of the property, the burden is discharged. Milord, what is the court's finding, milord? It is certain principle of law in so and so that initial burden to show that subsequent vending had no knowledge of the earlier agreement is always on the vending. The burden is discharged by leading negative evidence, which consists of a statement of denying the knowledge of the notice. After it is done, the burden shifts to the other party to show that the vendee had knowledge of the earlier agreement. When they merely by saying that I am in possession, I am a bona fide purchaser, the burden cannot be discharged. They have to prove that they have.
They said that they had no notice.
Yes.
They had
So
no
whether
knowledge
they have led any evidence, in that regard, that I have personally visited the site and they have used
That's
the.
it. We'll take. Third, when it counsels appearing on behalf of the parties with respect to a digital substantial question of proposed digital substantial question of law number 1.
One more judgment I have cited below.
On the same point? Same point के लिए एक judgment हो। मतलब जबरदस्ती का क्या मतलब है? अगर कोई पोजीशन में है
अपने हाई कोर्ट का मिलो इसी पॉइंट
तो सुप्रीम कोर्ट के आगे आगे अपना हाई कोर्ट चलेगा क्या? सुप्रीम कोर्ट का जजमेंट बहुत है, डीम नोटिस है, the person is in possession, he is in possession, इसको कुछ खास अलग बात है।
And there is specific finding, milord, I was only on submission, milord, if lordship hears the entire appeal first, milord,
देखिए आप सबमिशन दिया
milord,
बिना एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ डिस्पोजल किए हम पूरा अपील नहीं सुन सकते, तो आपको पता है, फिर आप इस तरह का प्रेयर ही मत करिए। आइए नंबर कौन सा आपका?
5577
आइए नंबर 5577 of 2026. Through this interlocutory application of 26 in essay number 423 of 2023. This appeal arises out of concurrent findings recorded by both the courts in titles and the plaintiff is the applicant before this court. आप सुन रहे हैं, आपको पता चल रहा है क्या बोल रहे हैं? हाँ? Plaintiff is the applicant before this court. The suit arises out of specific performance of contract and title suit is title suit number 48 of 1999. It is the Argument of the learned counsel for the petitioner that the suit claimed that an agreement of sale was entered into between the plaintiff and the defendant number 1 on 27/7/1997, 27/4/1997 for a consideration of 27,500, and there was strict timeline of 3 months to pay the entire consideration amount, and the same was duly paid. But in spite of that, the property was sold to the defendant number 2 to 5 by registered sale. The case was admitted on 19/7/2026 on the following substantial question of law. Inverted comma. Whether the plaintiff can be held to be non-suited for not paying the balance of agreed consideration amount within stipulated time, comma, though there is no finding of the courts below that the time was the essence of the contract. Inverted comma close. The appellants have taken 20 years to file this petition for framing additional substantial question of law. And they propose that the following additional question of law be framed. आइए नंबर
Double 5
इसमें जितना भी proposed है सब लिखेंगे. आपको मिलेगा पैरा नंबर 5. The respondents have filed their opposition to each of the proposed additional substantial question of law in their contract. The learned counsel for the appellant, while referring to the first substantial question of law, has submitted that the appellant was put in possession of the property and by part performance of contract, and therefore it was for the purchaser to come and visit the site, inquire from the petitioner, and find out if there was any previous agreement of sale and in what capacity the plaintiff was in possession of the property. He submits that this burden was never discharged by the defendants. Defendant number 2 and 3. दो ही purchaser हैं, बाकी लोग कौन?
Defendant number 1 is the original owner. 2 and 3 are husband and wife who are partly they have.
Party लोग?
दो ही.
By defendant number 2 and 3. He submits that this aspect of the matter has been completely ignored by the court. The learned counsel in that connection has referred to section 19B of the Specific Relief Act and has submitted that purchaser of property in good faith and without notice can only seek protection. Otherwise, he has got no right to purchase the property, and his right to purchase would be subject to. That should be enough.
Yes.
The council has also relied upon the Transfer of Property Act, Section 3, and has submitted that a person is said to have notice of a fact when he actually knows that fact, or when, but for willful abstention from an inquiry or search, which he ought to have made, or gross negligence, he would have known it. The learned counsel submits that since the defendant number 2 and 3 never made any inquiry which ought to have been made from the plaintiff as to how and in what capacity plaintiff was in possession of the property, it has to be taken that they had notice that the plaintiff was in possession of the property. And therefore, he has then referred to the judgment passed by Honorable Supreme Court reported in AIR 2000 Supreme Court SC 2921 as referred to paragraph 18, which is quoted as
from the appellate court judgment. We are reading page number 12 of the appellate court judgment. We are to mention as read paragraph page number 11. I am reading page number 12. I am going to the fourth line. The only argument advanced by the learned counsel for the appellant raised in this respect is that as the defense have denied the possession of the plaintiff, but the materials and the evidence on record shows that the plaintiff is in possession of the suit land. Hence, it is construed that the defendant number 2 and 3 have constructive notice of the said ignorance. In support of the contention relied upon so and so, it is pertinent to mention here that the facts of the said citation relied upon the responsible of the evidence different from the facts of this case, because clinching point of the principle settled in the citation is that possession of the party on the date when the subsequent purchaser made a third party. In this case, also, if it would have been, here is important. In this case, if it would have been established by the plaintiff that she was in possession of the suit land on 5/11/1987, it ought to have been. It would have been different, but there is no such pleading by the plaintiff in her claim that the execution of the alleged agreement to sell the defendant delivered possession of the suit land to the plaintiff in token of part performance of the contract. But the question arises when, and no answer of this question has been found. So the pleading there is a specific pleading there paragraph number 3 and 4.
आपकी एक बात है मुझे, आपको आराम से सुन. अब बीच में हम just disrupted my mind altogether. तो आपको मना किए थे प्लेस करने के लिए. Did I stop you? I did not stop. When I started dictation, you start again. It is never ending. हम order reserve कर देते, बात खत्म हो जाती. ऐसा तो आपने substantial question of law तो नहीं बनाया है additional. ऐसा आपने additional substantial question of law नहीं बनाया है that you have pleaded that you were put in part performance of the, you were put in possession of the property as a part performance of contract. It is not your pleading. तो हम क्या करें? That is not your additional substantial question.
And
therefore nothing. The learned counsel for the respondent, on the other hand, has submitted that the proposed substantial question of law is Do you want to say, did you plead that you were put in part performance of contract?
No, that's it is not part of it.
Did you plead?
Yes.
अभी सुनेंगे और अभी cost लगा देंगे, बहुत heavy cost लगा
In
देंगे.
the plaint, yeah.
In the plaint,
Yes.
you pleaded that you
Yes.
were put in part
Yes.
performance of
Yes,
the
paragraph number 3 and 4 of the plaint.
of your plaint.
Plaint.
Read it, please.
That after the execution of the above agreement, the defendant number 1 delivered possession of the suit land to the plaintiff in a token of proof of part performance of the contract to the defendant number by the defendant number 1, and also defendant number 1 received balance of rupees 5,500 on 15/5/1987 from the plaintiff in presence of the witnesses on tendered by the plaintiff. That paragraph number 4. The plaintiff, after paying the balance consideration money of rupees 5,500, defendant number 1 on 15/5/1989 requested defendant number 1 to execute necessary safely, but defendant number 1 assured the plaintiff that since the possession of
Statement, but
sorry.
WS. Yes, mister.
Yes.
How does the court record that there is no such pleading? How does the appellate court record that there is no such pleading that they were put in possession by virtue of part performance of the agreement? But there is no such pleading by the plaintiff in a plaint
that after execution of the alleged
that after execution of the alleged agreement, the defendant number 1 delivered possession of the suit land to the plaintiff in token of part performance.
that pleading is there, paragraph.
If pleading is there, this finding is perverse.
This pleading is
It has to go.
this.
If a person is put in part performance of contract, he has got lot of right.
Now question arises.
No, we will see what question will arise. We will decide it when the second appeal is
because
decided. But if such a pleading is there, what is your written statement?
yes, we have categorically replied to that.
Maybe denied, but this finding of the learned appellate court, how does the appellate court give this finding?
This is contrary to the record, para 3, because I cannot say that it is in consonance to the record. This part is concerned.
तो ये तो
But-
क्या बना दिया substantial question of
But it is not a proposed substantive question of law. Additional proposed question of law.
court
It is-
can always frame substantial
court can
question.
frame if at the time. But now the thing is that the findings of fact do change. The remaining amount, payment of the balance amount, which is
That is a separate thing. We will come to that later.
because that is the question of law which has been framed.
No,
and that is
no. We will come to that later.
the primary reasons for the learned courts below is for deciding the matter is that the balance amount of consideration 5,500 that has not been paid, and they failed to prove the payment of that amount. Para 3 they say.
Wait a second.
Para 3 they say that
Just
we
a
have
moment. The learned counsel for the respondents has submitted that the first appellate court has considered the issue whether the defendant number 2 and 3 are bona fide purchasers for value without notice, and has recorded that the plaintiff denied that he had any knowledge about the agreement. And therefore, the burden shifted upon the defendant number 2 and 3 that they had no knowledge about the agreement. He submits that the finding of facts would not be reappreciated in second appeal. At this stage, the learned counsel for the appellant has referred to further discussion by the learned court and has submitted that one of the prime consideration of the court with respect to prior notice is that there was no such pleading by the plaintiff that after the execution of the agreement, the defendant number 1 delivered possession of the suit land to the plaintiff in token of part performance of contract. nor there is any such recital about this in his agreement. And therefore, the court has recorded that the court cannot presume that the plaintiff was in possession of the suit land on 5/7/1997. The learned counsel has also submitted that. ये pleader commissioner report कहाँ से बोल रहे हैं आप? The learned counsel also submitted that a pleader commissioner report reveals that, which has been discussed in the appellate court judgment, reveals that it was the plaintiff who ultimately delivered the keys of the suit premises and has referred to
Pleader Commissioner's deposition P.W.6 number. Chandrasekhar. Page number 5, Lordship, 96. Your third line. To this adjacent, your suit land is within one compound and one door was there to enter the compound from the northern side. To this adjacent to the door, one house with tiled roof was existing. One door was on the northern side of the suit house for entering into the said house, which was locked. PW6 told both the sides to open the door of
he
the.
submits that PW6, who was the pleader commissioner, when asked both the sides to open the door, the husband of the plaintiff opened the door with his keys. The learned counsel submits that the finding of the learned first appellate court that there was no pleading with regard to delivery of possession of the suit land to the plaintiff in token of part performance of contract is itself follows. After hearing the learned counsel for the parties, वो 3 and 4 आप हमको दे दीजिए, हम सूट से हम अपने फाइल से नहीं निकालें. आपका 3 and 4 है ना? हम निकालेंगे तो फिर से बीमार पड़ जाएंगे, इसलिए please. It's correct, no? That is there. Are you aware?
Yes. The plaintiff's para 3.
Okay. During the course of hearing, it is not in dispute that the plaintiff had pleaded in paragraph 3 of the plaint that after the execution of the agreement, the defendant number 1 delivered the possession of the suit land to the plaintiff in token of proof of part performance of contract by defendant number 1. ...
The reply is in para 11 of the written statement.
However, it has been submitted that this aspect of the matter was denied by the defendants. Okay?
Yes, specifically denied.
Specifically. After hearing the learned counsel for the parties, this court finds that the learned first appellate court has resettled the issue and framed a new issue, that is whether the defendant number 2 and 3 are the bona fide purchasers for value without notice. Question mark. If so, comma, its effect, inverted comma close. However, while discussing the same, one of the prime considerations which has been taken note of is that the plaintiff never pleaded that they were delivered possession of the suit property as a part performance of the contract. rather recorded that there was no such pleading from the side of the plaintiff. In view of the aforesaid facts and circumstances, this court is of the view that the following additional substantial question of law is required to be framed in this case. Roman 1, we frame it. And then we will see what all evidences are there. What else?
Note 3. 3.
Roman 3 can.
Exhibit 9 has not been considered payment part. But I'm coming to direct specific finding.
Just a moment. Exhibit Roman 3. Non-consideration of material documents. ये ऐसा इस तरह का मत बताइए नॉन कंसिडरेशन ऑफ मटेरियल डॉक्यूमेंट्स तो पूरा यहाँ पे only exhibit 9 exhibit 9 क्या
Exhibit 9 is the 22,000 I paid at time of the agreement.
Okay.
The remaining amount 5,000 I paid, my lord, which is exhibit 9. This, my lord, that I am reading the finding, lord. There is absolutely no evidence from the side of the plaintiff that the balance consideration amount was paid to the defendant number 1 and Shankar Rao Chaurasa received the sum of rupees on behalf of defendant number 1. My lord, appellate court, page number 13.
Yes, I'm there.
Lord, from bottom page, line 18th line. Lord,
ऊपर से पढ़िए. So I will start with the fact that the defendant number 1 executed agreement of sale. Para 13. So I will start with the fact that the defendant number 1 executed the agreement of sale. तीसरा line ऊपर से. Para
yes,
page 13.
So I will start with the fact that the defendant number 1 executed an agreement to sell with the plaintiff as per the terms and conditions mentioned in the said agreement. Plaintiff was to pay rupees 55,000 to defendant number 1 within 3 months. The plaintiff has pleaded that said amount of rupees 55,000 was received by defendant number 1.
भैया पुराने जमाने की बात है 5,500. 55,000.
I'm sorry. 5,500. I'm sorry. It's time to cut. But the defendant number 1 has denied having received the same. Relying upon the decision of so and so, the learned counsel for the evidence submitted that adverse presumption must be drawn against defendant number 1, and it should be believed that plaintiff has paid the amount to the defendant number 1. There is no dispute about the ratio of the said citation rule relied upon by the learned counsel for the appellant. But
ये जो 5,500 का पेमेंट defendant number 1 का साइन है
defendant beta का sign, son, who is also witness in the agreement to sell. Lord, उसका कटा हुआ है Lord. Let me first refer to the evidence of the plaintiff in support of the payment of the balance consideration rupees 5,500. Only CW 9, 10 and 11 have stated about the payment of balance consideration, but all the three have stated that said amount was paid to the son of the defendant number 1, namely Shankar Lal Chaurasia. There is absolutely no evidence from the side of the plaintiff that the balance consideration amount was paid to the defendant number 1 and Shankar Lal Chaurasia received the same balance of defendant number 1. In the absence of the question of adverse presumption against defendant number 1 does not arise. Adverse presumption.
बेटा को कह दे.
Lord, son is also Lord, a witness to the agreement.
So what?
So he received, Lord, he came to the house, Lord, he received it.
How does that make a difference?
This one, Lord, it is.
जो वेंडर था आप उसको देते इस पर substantial question of law.
Lord, उसमें उसका Lord, he has signed, Lord, and the agreement also he has signed.
He might have signed it. घर में 10 लोग होते हैं 10 लोग साइन करते हैं लेकिन जो वेंडर है उससे साइन करते
Lord, if Lordship permit, kindly see exhibit 9.
नहीं, there is no doubt that
Lord, here his son has received, Lord. There is no such, Lord, I must admit, Lord, there is no such cross sign of the vendor, Lord, defendant number 1. neither there is any such, in the agreement also there is no such terms that he can receive also. But my lord, in the agreement to sell, my lord, his son has signed
It doesn't make any difference.
and he was a witness to the agreement, my lord.
He is a witness to the agreement. He's not a party to the agreement.
He is not a party to the agreement.
So therefore,
And my lord, this is my only case, my lord, that I have made 55 the out of remaining consideration I have paid, my lord. Only he is a son, my lord, of the defendant number 1. My lord, both of them have not appeared in the witness box, my lord, because of which I could not cross-examine and could not put them the very question. He is not a stranger. If you had been the power of attorney holder or stranger, that would be a different case. Now, he is the only son who has received. He was also, he would, if he would not have been a part in the agreement, then it would have been different. But he was also party to the witness and in the agreement. And there is the witness has also, in presence of the witness, this has been proved. This exhibit 9 has been proved by the witness, and in his presence, I came along with the son of the plaintiff, defendant number 1, to the plaintiff, and received it.
आपका तो प्लीडिंग ही यही है कि आपने डिफेंडेंट नंबर 1 को ही पेमेंट किया है. ऐसा तो कोई प्लीडिंग भी नहीं है कि बेटा को पेमेंट किया. नहीं, ये चाहिए.
नहीं, specific है कि paid to defendant number 1.
Just
Page 3, paragraph 4. Paragraph 3, which we have read, paragraph 3 also they have mentioned about defendant number 1 and paragraph 4 also. 2 places.
अच्छी
son के बारे में जिक्र
नहीं है ना. कहानी आपको कैसे चले. नंबर 2 के बारे में आपको क्या बोलना है.
Number 2.
So far as the second substantial.
Because the appellate court can formulate question of law, the concerned parties can hear.
That's so far
And the
as
case is not
so
with
far
consent
as the proposed second substantial question of additional substantial question of law is concerned, the learned counsel for the appellant does not know. With respect to third substantial question of
Third can be formulated considered time of hearing.
yes, we will. So far as the third proposed substantial question of law,
Third and fourth I am arguing jointly.
third and that's
Fourth,
that's right, that's right. Third and fourth substantial question of law are concerned, the learned counsel for the appellant has submitted that the learned courts have not properly appreciated it. Exhibit 9. No other documentary evidence has been referred during the course of arguments. He submits that the payment or balance consideration amount of rupees 5,500.
Balance consideration.
Balance consideration of rupees 5,500.
Exhibit 9, 5,000. My case is
5,000?
5,000.
Okay, 5,500.
5,500.
5,500.
It is
Exhibit 9 to 5,000 only. And 5,500 is cash.
Okay. लेकिन आपने उसमें प्लेट पे क्या लिखा?
5,500 लिखा हुआ है. But exhibit 9 is with 5,000 only.
Exhibit 9 relating to payment of rupees 5,000 to the son of the defendant number 1, who received the same on behalf of the defendant number 1, and remaining 500 was paid in cash. To whom? To the son of the defendant number 1. He submits that the defendant number 1 did not enter the witness box and failed and did not subject himself to cross-examination. The learned counsel for the respondents have opposed the prayer and has submitted that such argument is beyond the pleadings. He has submitted that the specific case of the plaintiff in the plate was that the remaining balance consideration of Rs 5,500 was paid to the defendant. It was never the case of the plaintiff that any amount was paid to the son of the defendant number 1 or any such amount was received by the son of the defendant number 1 on behalf of the defendant. They submit that this aspect of the matter has been thoroughly considered by the learned first appellate court, and therefore no such substantial question of law is required to be framed. After hearing the learned counsels on the third and fourth proposed substantial question of law, and upon going through the plate, it is the take care that I write it correctly. If you have your papers plain, it is the specific case of the plaintiff that the balance amount of is 5,500 was paid by the plaintiff to the defendant number 1. It was never the case that any amount was paid, much less 5,000 within bracket through exhibit 9 bracket close. Further 500 cash by the plaintiff to the son of the defendant. The learned first appellate court has discussed the materials on record in paragraph 13 of the appellate court's judgment, which is quoted as under. This court is of the view that no substantial question of law arises as suggested by the learned counsel for the appellant so far as the additional substantial question of law 3 and 4 are concerned. अब बताइए जितना आपका मुश्किल लग रहा है क्योंकि कंसिडरेशन का पेमेंट नहीं ऐसा लग रहा है बहस कर अब बहस बहुत ध्यान तो सुन लिए पढ़ लिए क्या बचा अब आपके जैसे असिस्ट करने वाले लोग होंगे तो हमको कोई दिक्कत नहीं है केस डिसाइड करने में आई एम जस्ट अप्रिशिएटिंग यू डोंट टेक इट बच्चे से तैयार होकर आते हैं जितना शांति से तो आप बहस करते हैं उतना ही शांति से हम सुनते हैं। हाँ बताइए अब आपको क्या बोलना
I come to the first substantial question of law first. Whether the plaintiff can be held to the mirror before I start, just giving you what the defense has taken stand on the WSP. When WSP they denied that the existence of any such agreement to sell defendant number 1 did not put their appearance in the witness box. Defendant number 3 and 2 and 3 were husband and wife. They denied, only simple denial is there that all the pleadings have been denied that there is no such agreement to sell. But the trial court gave a specific finding. There was an issue by trial court whether there is an agreement to sell valid.
Let us take it that there was an agreement.
The trial court has considered there was an agreement to sell. There is a
no
specific finding. Against which they have not approached them to prove any appellate court. They are not challenging this.
No
There was an agreement to sell is admitted by the parties. Now, my lord, therefore,
admitted नहीं है, but by now it is admitted.
yes, but by now it is admitted. Initially, they did not.
That's
Yes. Now, my lord, I I paid my lord 22,000 was also paid, but since there was a specific pleading by defendant number 1.
Where is the agreement?
Agreement is exhibit number 1.
देखिए हमको खोलना मुश्किल है
I
आपको
have
दिखाई
got a type copy, my lord.
टाइप कॉपी फॉर दिस
We have got also one type along with the original book.
टाइप कॉपी फॉर दिस
My lord, इसको देख लीजिए. Not legible, therefore I got a type. Lakshmi could have read both. I'm sorry. I'm sorry.
आप बहुत दिन बाद निकालने लगता हूँ।
नहीं
हम मर जाएंगे तो रेफरेंस पे जरूर पढ़िएगा कि आपकी कैसे होगा।
Sir, now I have to go, sir.
But these records will certainly curtail my life.
The next step is if lordship, if this matter spread over next date, I will create a compilation paper book.
अब next date क्या आप कल 4:30 बजने वाला आप एक बार 5 मिलियन के बाद कुछ नहीं
That's
नहीं
Friday.
नहीं नहीं
Friday.
नहीं नहीं
Friday.
नहीं होगा. Please do not tell me this. Otherwise, I will adjourn it for indefinitely. No. एक बार इतना फाइल सुनने के बाद खुलने के बाद अब क्या? No, nothing doing. नहीं कोई बात नहीं आप बहुत ज्यादा बिजी रहते हैं 2-4 आप जूनियर्स रख लीजिए बोल दिया करिए 11 नंबर कोर्ट पे तो पूरा सुबह से शाम तक के लिए फुर्सत हो जाता है नहीं हम नहीं I will not permit this no I will not नहीं तो अभी से 7 बजे तक सुन हाँ तो चलिए हम भी तैयार अब बहस करिए इसमें तो है टाइम इज एसेंस ऑफ कॉन्ट्रैक्ट टाइम इज एसेंस ऑफ कॉन्ट्रैक्ट क्लियरली तो करिए ना आंसर वही तो हम भी पूछ रहे हैं on the face of the agreement time is the essence of the contract merely because it is stated ऐसा नहीं है इसमें पूरा टाइम फ्रेम दिया है
end to end time date is mentioned
end to end
yes even then when I say time is not the essence of contract why so there is a two cases situation
no but first you tell me one thing
yes
did you prove payment of consideration amount
the agreement is admitted Miller
agreement is admitted
therefore Miller since there is a specified that there is an agreement is there Miller in 22,000 also proved because different number has not put their appearance
that's right I want to know did you prove payment of entire consideration amount
22,000 is proved Miller exhibit 9 Miller is the remaining consideration Miller
no that is not that is not remaining consideration that I will reject that is not remaining consideration I will not accept it it is absolutely at wages to your rate उसी पे आप satisfy करिए सब में कोई नहीं
Lord if I even assuming that I have not paid substantial portion I have paid even assuming that I have not paid 5,500 remaining consideration I have not been able to prove that there is no such pleading that I paid to the son of
is there any finding that you have paid the entire consideration amount
no
there is no finding
no.
There is no substantial question of law
yes
that whether the courts have come to a wrong finding that you have not paid the entire consideration
no, there is a specific pleading there is a specific pleading paragraph number 4 of the claim may kindly be seen again this is Campbell claim lordship has been paragraph number 4 will kindly be seen the full paragraph number 4 will kindly be seen I made a specific statement in that regard but what the surety a defendant number 1 has given Lord, read the full text. Lord, he has assured that since you are in possession of the property, enjoy your possession. I will execute send it later on. And in the meantime, Lord, he sold the property.
My question, please don't dodge my question. मेरा दिमाग वहीं अटक जाता है. उसके बाद कुछ सुनाई नहीं देता. हम आपसे ये जानना चाहते हैं, have you proved payment of entire consideration amount?
And Exhibit 9 is the only document.
Exhibit 9 is not going to cut any
Yes,
ice.
this is my only answer. Exhibit 9 is my only document. I have.
Okay, बाकी substantial question आपको आगे देंगे. Is there any finding that the entire consideration amount was not paid?
Yes, there is a finding.
There is a
There
finding.
is a specific finding. that
Ab
we
kya?
have to place in. The learned appellate court statement, page number 50. Page 50.
Because once they reject exhibit 9, there has to be a finding.
Exhibit 9 has to be rejected for more than one reason. First is that it is their case is that it was received by different number 1, para 3, para 4 given to different number 1. Two places, different language but same thing, to different number 1. Now it is evidence beyond pleading. Order 6, Rule 2, CPC negates such a evidence beyond pleading. Then other reason is that document
The plaintiff has failed to prove
yes,
that she
yes.
paid the balance consideration amount of rupees
Different amount.
5,500.
yes, specific.
Ignoring Exhibit 9.
Ignoring exhibit 9.
It is beyond pleading.
Just he's arguing something.
Yes.
He says that if substantial amount has been paid, then also he has a right for specific performance.
That is not the
No, Betty, he wants to argue. Maybe that we are not aware of it. Yes.
Yes.
One second.
That is 1977 Supreme Court, they rushed it there. 1977 Supreme Court, 1004.
ये तो पहले भी साइट हो चुका है कई बार. देखिए खोजिए जरा. 1977 Supreme Court.
I have one copy. Lord, before I read, Lord, there are two situations, Lord. If Lordship, before Lordship may kindly read, Lord, section 55 of the Contract Act. Section 55.
Yes. There is no likelihood of any case being taken up. If you find it interesting, it's okay. हाँ बताइए. अब यहाँ पे हेल्थ का थोड़ा ध्यान रखना.
Section 55 of the contract.
चलिए बताइए क्या बोलना चाहते हैं आप section 55. Actually, this case is. आप लोग का कहानी खत्म हो गया. Additional evidence. Amendment का. Amendment भी तो है आप लोग. जवाब आ गया. तो अभी तो आइए भी पे चलते रहेगा. नहीं कल नहीं. Tomorrow नहीं. वो it will have its own day. हाँ बताइए. आपको इसका कुछ फाइल करना है तो आप भी कर दीजिए. मिस्टर श्रीवास्तव, आपको इसका कुछ फाइल करना है तो कर दीजिए. Next day.
Effect of failure to perform a fixed time in a contract in which the time is essential. When a party to a contract promises to do a certain thing at or before specified time, or certain things at or before specified times, and fails to do so, such things at or before specified time, the contract or so much of it as has not been performed becomes voidable at the option of the promisee, if the intention of the parties was that time should be the essence of contract. Not it is voidable at the stance of promisee, if the intention of the parties was that time should be the essence of contract. Not if the intention has to be seen. Now, there are two phases of this section 55. I'm just illustrating. If there is some marriage in a family in which flowers has to be delivered. I'm reading. This is the example which is the old specifically. There is a 20th. Suppose 20th July was the date for marriage. If I have ordered a flower in the marriage which is to be delivered, which is marriage is solemnized on 20th. Then if suppose the flower is delivered on 22nd, then here time is the essence of contract. Then contract will fail. If suppose we have not mentioned any date, marriage has to be solemnized. This is the only contention. Then if the flower is delivered at a later period, although there is no purpose has not been mentioned, then in that situation, time is not the essence, In that situation, it can be extended. I can be charged some penalty, penal charge, and something. Now, in that stance, kindly take this 77 Supreme Court. Paragraph number 5. The first question that arises for consideration is whether the time was the essence of contract. In order to determine this question, it is necessary to set out that the suit agreement, which is marked exhibit 23 at page number 4. The agreement, what I will put it. I'm reading paragraph number 4 of the agreement, same column. That you must get the sale deed executed within 2 months up to 24th May 1964. This is exactly my case. And in case you do not get the sale deed registered within 2 months, then the earnest money amount of rupees so and so paid by you shall stand forfeited without service of notice. But in case we in same way evade execution of the sale deed, then you will be entitled to compel us to execute sale deed legally, and we shall be liable to pay the cost and damages incurred to you. Now, I'm reading after the agreement is closing, the relevant clause in the second column. May I please?
The remaining amount was to be paid at the time of release.
Yes. You must get the sale deed executed within so and so. This is also in my case also. Time was fixed.
In your cases, that within 3 months the entire amount was to be paid, and then steps for registry was to be taken.
Yes.
In the agreement which you are, in the judgment which you are citing, the balance consideration was to be paid at the time of registration of it. Remaining sum of rupees 20,000 shall be paid by you to us at the time of registration.
I'm reading again for me.
अरे paragraph 2 तो पढ़िए ना agreement का.
That you are paying us the present sum of 4,000 in cash to the earnest money. The receipt thereof has been acknowledged by us in fixed revenue stamp in the proof of the letter, and the remaining amount of 20,000 shall be paid to us at the time of registration. On paragraph number 4.
I've read.
Yes. Now let's second column. Second column. Page number 1007. After the agreement. The relevant clause is clause 4, which provides that the applicant must get the sale deed executed within 2 months, that is 24th May 1964, and in case the applicant did not get the sale deed registered within 2 months, then the earnest amount of rupees 4,000 paid by the applicant shall stand forfeited without serving any notice. The clause further provides that in case the respondents in some way evade the execution of sale deed, then the applicant will be entitled to compel them to execute sale deed legally, and the respondents shall be liable to pay cost and damages incurred by the applicant. It is settled law that fixation of the period within which the contract has to be performed does not make the stipulation as time the essence of contract. Then, when a contract relates to sale of immovable property, it is normally be presumed that time is not the essence of contract. The reference has been made. It may also be mentioned that the language used in the agreement is not such as to indicate it unmistakably the terms that the time is the essence of contract. The intention to treat the real time Intention to treat time as the essence of contract may be evidenced from by the circumstances which are sufficiently strong to display the normal presumption that the contract for sale of stipulation as the time is not the essence of contract. Now, Lord, another statement, Lord, this is.
How does it help you?
Yes, Lord, this Lord, again take another statement. This will
No,
clarify
no.
further.
You see, whether the plaintiff can be held to be non-suited for not paying the balance of the agreed consideration amount within stipulated time. You did not pay only.
Lord, the first agreement you
You did not pay. This substantial question of law which has been framed at that point of time, it was not pointed out that there is a finding of the court that the balance consideration amount was not paid. You read the substantial question of law.
Whether the plaintiff can be held to be non-suited for not paying the balance of the agreed consideration amount within the stipulated time, though there is no finding of the court
Need not
the
be.
essence of the contract.
There is a finding of the court that he did not pay the balance consideration amount.
But that's why I say exhibit 9.
No. That I have already rejected. देखिए ऐसा है कि आज एक सब्सटेंशियल क्वेश्चन ऑफ लॉ तो बनाए हैं, एक टाइम दे देते हैं, लेकिन जब तक आप बैलेंस कंसिडरेशन का पेमेंट नहीं दिखाइएगा, देयर इज नथिंग, बस कहानी खत्म है आपका। नहीं फ्रेम कर सकते हैं, गलत चीज नहीं कर सकते हैं। देखिए आपको बहुत कॉन्फ्रंट किए, लेकिन फिर भी हम एक क्वेश्चन फ्रेम किए, राइट, आफ्टर आस्किंग यू स्पेसिफिक क्वेश्चन। वैसे ही चलता है मेरा को, हमको कोई दिक्कत नहीं है अपनी गलत बात, अगर मान लीजिए कुछ हमारे मुंह से निकल गया कि ये चीज ऐसा है, अगर आप पॉइंट आउट कर देंगे ये चीज ऐसा नहीं है तो आई विल एप्रिशिएट इट। बियॉन्ड प्लीडिंग थोड़ी सब्सटेंशियल क्वेश्चन ऑफ लॉ बना देंगे। सेकंड अपील इज अ टफेस्ट बोल ऑफ हाई कोर्ट। इसमें बहुत केयरफुल रहने की जरूरत है। एक गलत जजमेंट कर देंगे, इट बिकम्स बाइंडिंग ऑन द एंटायर स्टेट। तो बिना हायर कोर्ट को हायर बेंच को रेफर किए नहीं हो सकता।
सब केसेस सुप्रीम कोर्ट
जाते हैं सब, आप गलत फहमी में, सब जाते हैं क्योंकि कम्युनिकेशन तो हमारे पास आता है ना, सब जाते हैं। 84 का सेकेंड अपील भी चला जाता है सुप्रीम। जमीन की लड़ाई है ना, आदमी मर जा रहा है लेकिन उसका जनरेशन तो वही है, और यहाँ पे कोई एम्प्लॉयमेंट जनरेशन नहीं हो रहा है कि कोई कहीं चला गया कोई कहीं चला गया, नोबडी इज बॉदर्ड। यहाँ पे जो एक कमरे का लड़ाई है ना, वो किसी भी इंडस्ट्रियलिस्ट के इंडस्ट्री के लड़ाई से बड़ा लड़ाई है। यहाँ पे लोग ईंट के लिए लड़े, नहीं चलेगा। बताइए कब करना,
क्योंकि आधा तो फैक्ट्स तो आ गया।
देखिए हम तो अब दोबारा बोलना पड़ेगा,
सब्जेक्ट टू कन्वीनियंस ऑफ द अदर।
लेकिन भाई देखिए ऐसा है एक सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम किए हैं क्योंकि हमको ये आइडिया नहीं था, नहीं तो हम वो भी नहीं फ्रेम करते। अब कर दिए हैं तो हम कुछ नहीं। अब आप बताइए, इसीलिए हम सेकेंड अपील बहुत ध्यान से सुनिए, ठीक है। ऐसा चीज नहीं है कि इसको हम लोग दागता है, आपने मेरे लिए दिया है, लेकिन देखिए आप हमको कल तक ये सब जैसा हाईलाइटेड था एकदम सेम टू सेम आना चाहिए, क्योंकि मेरे फोटो से लिख पे नहीं। अगर आप रेड पेन से हाईलाइट किए ना तो रेड पेन से ही हाईलाइट करके दीजिएगा, अदरवाइज आपको दिखाई नहीं देगा ठीक से, ठीक है। हम उसी को कैच करते हैं, जिसका टाइप कॉपी, इसका ट्रांसलेटेड कॉपी, ठीक।
इस वीक नॉट टुमारो,
हाँ इस वीक पे चल सकते हैं, किसी चल सकते हैं, फ्राइडे को हम फिक्स होगा
असाइन मैटर में के पास
फ्राइडे को कुछ फिक्स टाइम कौन सा फिक्स आठवें है कोई तो क्या ही बात है। हाँ तो छोटा सा फर्स्ट अपील में इसी को सुनाएंगे। Pose this case for hearing on merits. Friday at 2:15. कर लेंगे? तो अभी photocopy कर ये document photocopy करवा अभी करा के ये list of dates
Like given the list of dates also.
okay. किसी का कुछ बच रहा है क्या?
serial number 8 को next week में
8 में क्या है?
वही जो orders mention किए थे
ऑर्डर्स हाँ क्या हुआ था?
मैंने जो serial number 70 जो orders में एक आई पे है notice है interview application serial number 70
आपने आई को फाइल कर दिया
वो notice मतलब वो limitation petition
कौन सा?
actually
सिर्फ लिमिटेशन है ना? कितना दिन का दी?
400 days देना है
अच्छा
और उसमें भी सेम एक अपील फाइल हुआ हुआ है हम लोग फाइल कर दिए थे देवघर कोर्ट में और फिर हम लोग वहाँ पे विड्रॉ हुआ पेक्यूनरी जुडिक्शन पे इस बार यहाँ पे फाइल हुआ
वो एडमिट हो गई
वो फिर हम लोग का यहाँ विड्रॉ किया दो अपील है एक और अपील है जो कि वीडियो के द्वारा ये किया गया जब नोटिस किया गया सेम राइटिंग आउट ऑफ द सेम इनका 13
number 238 of 2026 let notice be issued on IA number 5817 of 2026 seeking consideration of delay in filing the appeal. एक ही respondent है?
जी
नहीं कई सारे respondents हैं. To the respondents for which requisites to speed post and orderly process be filed within 10 days.
it may be time with along with this date also writing on
कब है date इसमें?
इसमें 13 को
Post is post on 13/8 उसी दिन बताइए पोस्ट ऑन 13/8 ऑफिस टू टैक्स पीपल तो 10 दिन का टाइम नहीं देंगे फिर आप एक हफ्ता में करिए
जी सीरियल नंबर 8 में भी रेस्पोंडेंट नंबर 1 को नोटिस के लिए अभी तक
आप तो चाहे सुबह से आप बैठे हैं आपको तकलीफ लगता है
इसको नेक्स्ट
पॉसिबल नहीं कल कर रखिए
आप देखिए बहुत सुबह से बैठे हुए हैं पता है ये क्या बोल रहे हैं क्या बोलना चाहता है आपका बात नहीं समझ
I am the respondent number 2 and 3 respondent number 1 is Dabur India company
अच्छा हाँ बताइए तो क्या हो रहा है आपका ये
जो इसमें
पेपर एप्लीकेशन
ऑर्डर नंबर 10 very simple please direct they apply to take steps regarding respondent number 1 and 60
तो 1 आप किसकी तरफ से हैं
2 and 3
16 का क्या हुआ
60
ऑर्डर नंबर 10
ऑर्डर नंबर
1 and 60 could not be served 60 का क्या हुआ
तो इसके I have submitted the requisites let the requisites be let the notice be
हम ही चले जाते हैं लेकर
order passed to you utilize the same
हम ही चले जाते हैं लेकर
नहीं तो जो उसमें हुआ क्या कि रिलेटेड फाइल हुआ था इसलिए अब नहीं है
इसीलिए तो बोल रहे हैं, हम ही चले जाते हैं लेकर
प्रिंटर नहीं था तो वो कैसे खत्म हो जाता लेकिन इसी को utilize
FNM 304 of 2023 the learned counsel for the petitioners appellant has submitted that the notice
step submitted
steps for notice upon respondent number 1 and 16 have been taken though belatedly and therefore the notice could not be issued. Office is directed to send the notices so filed, for which requisites have already been filed. Post this case, fixing the next date of hearing. Fixing the next date in the matter as 27th August. ठीक है? Post on 27th. हो गया?
Serial number 19, madam.
आप तो नहीं mention किए थे?
No, I have not mentioned, but with the consent of the other side, I am mentioning this case, madam.
चीफ साहब को बोलिए कि 6 बजे तक कर